Dear ladies and gentlemen, distinguished speakers and guests, it is my great pleasure now to formally close this conference on behalf of the International Nuremberg Principles Academy. I would like to take a brief moment to pay tribute, to appreciate and to savor these very rich discussions that we've had over the past 2 days. All the arguments on the legal, the political, the normative and the practical dimensions of the very theme of this conference has only been possible due to the breadth and the depth of experience and expertise that we have assembled here in this very room. The topic of the Nuremberg Forum 2019, the Nuremberg Principles, beyond the International Criminal Court, a common ground for accountability, has proven to be a very timely topic, and a sense of urgency, of real urgency, has occurred while listening to the speeches and the interventions of our distinguished panelists. I will not attempt here to summarize, but I would like to take a moment to, well, if you like, emphasize some key points that emerged from the discussions. Gathering here in Courtroom 600, a truly congenial setting to discuss topics of international criminal law and accountability, reminds us of the ongoing significance not only of the Nuremberg Principles, but also really acutely reminds us or makes us aware of the current pressures and challenges and the current situation we are in. The rule of law obviously forcibly entered the vocabulary and the agendas in the international legal and political arena ever since 1989. Incidentally, this year also is the 30th anniversary of the fall of the Berlin Wall. And currently, 30 years on, in light of the populist and the nationalist tendencies that we see and trends, authoritarian regimes on the rise worldwide, concern has been expressed, as has been done here in the last 2 days, about rule of law backsliding, about the undermining of rule of law worldwide. And certainly the rule of law doesn't perpetuate itself automatically, but must be defended by lawyers, but also, of course, by civil society, by all of us, by citizens. We have heard several observations of pressures on international courts, on international mechanisms, yes, on international organizations more generally, what has been called contested multilateralism or pushback of international law and against international courts. I think many of the speakers have identified blatant impunity gaps, but also reminded us of the formidable advances in the fight against impunity and the centrality of accountability in our world today. There have been very dense and rich discussions over the last 2 days in the past 6 panels, and allow me to just pinpoint to some of the tasks and themes that have emerged and have been repeatedly emphasized. So one, of course, was a review of the proliferation of the ad hoc tribunals, the ICTY, the ICTR, the Special Court for Sierra Leone, the Extraordinary Chambers in Cambodia, the STL, but also how the field in itself has progressed ever since the early 1990s, and we see an increase in national proceedings, but also a proliferation with remarkable velocity in the recent years of new types of mechanisms being created, namely investigative mechanisms, and we've just been reminded of their relationship to more formal accountability mechanisms. What has been emphasized is the variation of all of these mechanisms, their variation in terms of whether they have primacy in terms of jurisdiction, how they were negotiated in the first place, what their mandate was, what institutional design they had in the first place, how then their mandates were implemented, and what effects actually came about of this multitude of mechanisms. The funding models have been discussed, the support they enjoyed, both by states as well as civil society, as well, of course, and importantly, by the affected communities themselves. A number of other topics have been elucidated, namely the ad hoc nature or the temporary nature of much of these mechanisms that we have been dealing with. And linked to that, the complex interplay of permanence and impermanence, of idealism or principle-based arguments and pragmatism, of distance and proximity, and of law and politics, of course, and without then falling into the trap of false dichotomies or strict binaries. Paramount also has been emphasized that we should pay attention to language and the precision of language, as well as the specificity of the mandates attributed to these mechanisms. Another theme that emerged, and that was highlighted time and again by the speakers, is the multiplicity of actors. These are, of course, the negotiators, the policymakers. These are also all those involved in the judicial mechanisms, also the victims, and, of course, civil society. But linked with that recognition and that emphasis is a multiplicity of voices. So we've been mindful, and I think many of the speakers have done this, an unpacking of some of the more abstract terms of international community, civil society, victims, whose voice is actually being heard and whose voice is listened to. Another emphasis has been placed on context, both in time and in place, and highlighting the idiosyncrasies and the particularities of many of the unique contexts that we have discussed and heard very powerful empirical testimonies to. Lastly, the balance or the highlighting of both capacity as well as the political will to do something, and we've heard what this something might be in the very rich discussions, again, on the multiplicity and the variation of the different mechanisms, but the political will vis-à-vis the impasse in the UN Security Council, but also of states, of course, to establish such mechanisms in the first place, to then fund them, to cooperate, and so forth, as well as to hold national proceedings when warranted. Another aspect that was highlighted is to complexify the debates, to challenge ourselves and the types of narratives that are told both possibly at conferences, but also in some general remarks and in discourse and generally. So to interrogate the legal, the political, and the social cultural understandings, the meanings of justice and the multiplicity of meanings, the role of narratives, which may be complementary or conflicting, and to actually question narratives in and of themselves, to question some of the paradigms, the underlying assumptions of the field. Some of the double standards were mentioned, but also to think about practices. This includes legal practices, but this also, of course, includes practices at the court, such as outreach or engagement with the general public. And this, of course, includes publicity and the role of the courts to answer, if you like, in a public arena. Darren Bentham reminds us that without publicity, all other checks are insufficient. In comparison with publicity, all other checks are of small account. So in other words, the functions of courts and of mechanisms are multiple, but this engagement in the political arena and have transparency of the work done and the very important work done of these mechanisms is equally important. Now, finally, it was, of course, mentioned, or a common theme was that there is no one panacea. There's no one-size-fits-all model, which, again, allows us to inquire and question some of the kind of centralizing or essentializing tendencies that we see. Certainly not everything is moving as fast or going as far as one may wish, but I did sense a kind of delicate sense of optimism here in the room that has been mentioned time and time again, but of course expectation management is a key task for all of us. So allow me finally to, of course, come to the official thank yous that are warranted on such an occasion. First of all, Professor Leila Sadat, I'd like to thank you for a really inspiring, truly exceptional keynote speech, and also I'd like to thank all the distinguished speakers and chairs. It's been truly inspiring and encouraging to hear your really insightful and acute observations. Thank you very much. Then I'd, of course, like to thank all the colleagues that have made this event possible. We work very closely together with the colleagues from the Higher Regional Court of Nuremberg, with the colleagues from the Memoriam, all the service providers who have made this possible, as well as, of course, a huge thank you to the entire team of the Nuremberg Academy who've worked tirelessly for months to put together this high-caliber event. Thank you very much. And then lastly, I'd like to thank again all of you who are here in this room with us, assembled here. Thank you for your interest. Thank you for your active participation. Thank you for coming to Nuremberg on this occasion. And in closing, I invite you all to stay engaged. We at the Nuremberg Academy certainly will continue to do so. We're already thinking ahead to our plans and programs of the next year, and allow me on this occasion to end with a save the date. The Nuremberg Forum, as you know, is an annual occasion, so bear in mind the 16th and 17th of October next year. Nuremberg Forum 2020, you are all invited to join us here again, and no surprise, the theme of the conference will tie into the 70th anniversary of the Nuremberg Principles, which is next year, in light of the contemporary challenges and the new frontiers of international law that we are seeing. So allow me to thank you, wish you all the best, a pleasant remainder of the day, safe travel onwards, and look forward to staying in dialogue. Thank you.